Hi guys, it's Kathy. I hope you're doing well. I'm not using my camera today. My eye hurts. I have the lights off. I'm not using my camera today. And it makes this first clip worse. So this first clip, it's not too long. It's like a little over 10 minutes. It's a telephone Zoom conference. So there's no cameras. It's just the telephone number on the screen. But the rest of the clips, are normal. This is just the telephone. No, you can't, V. You're not. I'm not turning my camera on today. Just not. Look, I stream every single day. I can take this day off. But I can still play them. I can still play this. Here we go.
Yeah, I'm going to take you off speakerphone. Hold on. Okay, can you hear me?
Yes, thank you. So this is Magistrate Doak. Thank you for your patience.
Sure.
So I
What's
have
your last name? D-O-G?
Doak, Doak, D-O-A-K.
D-O-A-K. Okay.
So I'm going to ask you a
Okay.
few questions.
Of course.
But before I do so, I'm going to get you sworn in. Can I have you raise your right hand, please?
Okay.
Do you swear or affirm under the penalty of perjury that any testimony you provide me today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Is all the information that you provided on your complaint that you filed true and accurate?
Yes.
All right. So it appears that you and Mr. Cabrera are neighbors. And I'm not clear the most recent incident. One it
Today.
indicates a date that hasn't yet happened. It looks like 2/30,
Yeah, I
2027.
accidentally put two, but it was today, 1:30,
Okay.
26, and then one
So
on
what?
this past Tuesday.
Okay. So
It's
what
been
on?
ongoing since 2023.
So what today happened? You indicated that on 2/30, but I'm assuming you mean on January 30th, he approached you wanting to, and then you have a question mark. What does that mean?
Well, he approached me downstairs, and it's all on camera and video. I had called the police like 4 times on him, and the police here in Fort Collins told me do not engage with him, stay away from him. And I said, okay. Well, today he was coming towards me, and I said I was on the phone, and he was going to try to talk to me, and I'm like, I'm on the phone. And then I said, stop, stay away from me. You're not allowed to talk to me. He goes, well, I'm looking for someone. And I said, clearly, that's not me. So then I came upstairs because I was downstairs. I came upstairs, and he and his, I don't know what she is, girlfriend, wife, I don't know. I've heard both. I've run a background on him. He's not married. He's like, yeah, she said she didn't want to talk to me. Like, I would want to talk to her. Ha, ha, ha. And I'm like,
So ma'am, hang on 1 second. What did he do today? So you said he approached you and he wanted, so in your complaint, you said he approached me wanting to question mark. What does that mean? I don't want to hear a history of what's happened. I want to know what happened today. What did he want to do?
I don't know. Talk to me is what I'm assuming.
Okay.
And then, I stopped him in his tracks.
Okay, hang on 1 second. So you indicated all of the above, and I think those are different dates that you're referring to. He approached you and you were afraid. What was it that made you afraid when he approached you?
Because he's supposed to stay away from me. I've made a complaint to management, Fort Collins Police Department. He's aware he's not supposed to talk to me or engage with me because I'm afraid of him.
Okay. And what is it that he's done to make you afraid of him? Has he threatened you?
Yes.
And in what way?
He told me because he wanted to date me back in 23. Well, he did. But anyway, I broke up with him because
Okay, so the two of you, had a relationship together?
Yes,
Okay.
but
You
not a
indicated
sexual
on your,
one.
that it was or was not a intimate relationship?
It was not an intimate relationship. I never had sex with him,
Okay.
thank God.
Okay. All right, because on your
So,
complaint, you just indicated that he lives 3 doors away. So there wasn't
well,
any
yeah.
mention of prior. So hang on 1 second, ma'am. So when I'll ask you some questions, and I'll just ask that you don't interrupt me. I have
Okay.
to make some specific findings, okay?
Mhm.
So I'm just trying to get some information as to
Sure.
determine whether or not the law actually allows me to issue a temporary protection order. So, and if so, what sort of order I issue. So I'm just trying to get some information. So the two of you had a relationship, not intimate, 3 years ago, and you indicated he wanted a child with you. Is that right?
No, no, that's incorrect.
Okay. You said that he wanted a baby.
I barely had
Where,
room to write. I don't understand how I put baby.
no, you just said that on the record today. So you said you had, and maybe I misunderstood you. When I asked you
Yeah,
what he
no.
has done to make you afraid, you said we had a relationship and he told me once he wanted to have a baby.
No, sir, that is incorrect. I'm too old
Okay.
to have kids.
Okay. So what is it that he has done to make you afraid?
Okay, well, he is a felon and has robbed a bank.
Okay.
And I found out later, and he told me, because, I was saying, I don't want to see you, this and that. He says, you know what? I used to hang around a lot of bad people in Arizona, and he was in federal prison. He said, all he has to do is make a phone call.
And what did that mean?
That means if you cross me or if you try to get me in trouble or kicked out or whatever, that's all he has to do is make a phone call.
And what if anything has he done in terms of direct threats to you? Has he ever physically harmed you?
No, not physically, no.
Okay. And has he made any direct threats? Like, if you do this, I'm going to, anything
Yeah,
like
but
that?
just what I said. All he has to do is make a phone call.
Okay. All right. So I am going to grant the complaint. So I'm going to issue a temporary protection order on the basis that there's been a threat.
Yeah.
Although it's a little tenuous, and I'll be honest with you, this is pretty thin. But I'll
It's
issue
pretty
the
what?
protection. It's pretty thin in terms of, I mean, I'm not hearing any
Well, you don't
outward
know the
threats
past.
necessarily. And so
Yeah.
what we're going
Well,
to do is I am going to issue the temporary protection order. And we'll get the matter set for a permanent protection order hearing.
mm-hmm.
And at that hearing, it'll be your burden to prove to me that the acts
What
that
he's
gave
done.
rise to the issuance of the protection order, that there were threats made against you,
Right.
did happen. And
Mm-hmm.
it's your burden to prove to me that without further protection, that those acts would continue, or there would be
Yes.
other acts meant to intimidate or retaliate. So
Right.
we're gonna send you what's called a temporary protection order service packet. That's going to include the temporary protection order. It's going to include your complaint, and it's going to include the notice of our hearing date. And that
Okay.
hearing date is going to be set February 11th,
February 11th.
2026. Uh-huh.
Okay.
2026 at 10:30 a.m.
10:30. What day is that? Do you know?
till Wednesday.
Wednesday. Okay.
And so I am going to list you as the protected person. What I'm going to do, can you tell me, so you indicate that You live 3 doors down. You live in an apartment? Do you live in a
Yes, sir.
house? You live in
Apartment,
an
sir.
apartment. Okay. So that becomes tricky for
Yeah.
enforcement,
Yeah.
purposes. So what I am going to do is list that there be a 15-yard distance restriction from your
15
person.
yards. How far is that?
15 yards, multiply that by 3, it's 45-ish feet. So less than 50 feet. But given that you work in or live in an apartment, there's a potential that the
more?
2 of you will be sort of crossing paths or whatever.
Linus, thank you so much. Thank you.
I am going to allow that he'd be able to continue to go in and out of his residence, but that he needs to stay at least 15 yards away from you outside of his residence.
Yeah.
So we'll get the matter set for this hearing. So you'll be required to get him personally served.
What does that mean?
Yeah, and what you're going to have to do is there's Colorado rules of procedure, civil procedure that you'll have to follow. And specifically, if you want the number, you can read this. It's Colorado Rules of Civil Procedure, Rule 4E. But essentially what that says is that you have to get him personally served, and you have to utilize somebody over the age of 18 who is not a party to this case.
Okay.
So you can hire a process server. You can use the Larimer County Sheriff's Office. They have a service for this. If he is, and once you get him personally served, you'll have to file with the court your certificate of service.
What's a certificate of service?
Something you should ask a lawyer.
Excuse me, if and when you talk to the Larimer County Sheriff's Office, they'll let you know what that is. They fill out an affidavit of service indicating the date and time that they were personally served. So you need to get that filed with the court so I can make findings.
Okay, so I have to contact Larimer County Sheriff, not Boco Police Department.
I don't think the Fort Collins Police Department has a service department. I know the Sheriff's Office does. So you don't have to contact them. That is a resource for you. Again, you can.
Can I have like a neighbor do it?
You just need to make sure it's somebody who's not a party to the case, wouldn't be a witness to the case, anything like that.
Okay.
Over the age of 18.
Okay.
And so
now, could we put it on his door?
It has to be personally served.
Okay.
So you can read the rules, and the sheriff's office knows what to do. And certainly any process server would know what to do as well, private one. If he is personally served and he does not show up, the court will have to enter a permanent protection order. If he is personally served and you do not show up,
I will.
You don't have to appear, but without more information by way of testimony or evidence, I wouldn't be able to make the findings that I would need to. And so if that happens, likely what ends up happening is I vacate the temporary protection order and dismiss the matter for your failure to prosecute.
Oh, no, I've been waiting for 3 years to do this. So,
and if you're unable to get him served and you appear, we can issue an amended temporary protection order with a new court date and allow you the opportunity to try to get him served. And we would get the matter reset within 2 weeks. Okay. What you'll want to do is get any exhibits filed with the court prior to your appearing in court. So any exhibits, well, if you intend to offer exhibits into evidence, you'll want to get those filed with the court prior to the hearing date.
Filed before. Okay, like receipts of, because see, he would sell me his food stamps and want me to give him cash. I have receipts plus things I bought him, plus like she'd say, I'll spend $30 on food, and then can you give me $30 for protein powder or stuff like that? Is that what you're talking about, or clothes or whatever?
Well, yeah, anything that you believe is important for the court to consider. Again, it's going to be your burden to prove to me. So any evidence that you think will help you prove your case, you'll want to get that filed with the court.
Okay, prior.
And I'll just let you know, just because they're filed with the court, those are all proposed exhibits that would be subject to me making orders of their admissibility at the hearing. Okay.
Okay. Can I ask you a question?
Yes.
So I have RA,
That's all
and
you've been doing.
all this stress has really been difficult on my body. Can I get doctor's notes, because they're aware and it's all documented? And then he had access to my home, and he would steal my medication, like my gabapentin. He would steal medications. He had complete access. What about things like that?
So, ma'am, I can't give you any legal advice.
No,
So
but
if
should
you
I
think-
bring things like that? Proof. Like I have everything documented.
After giving her 23 minutes of legal advice.
I can't give you any legal advice on how you should go about proving to me what it is you need to prove to me. So if you think there are things that are appropriate, admissible, that will all be up to your determination. Okay.
And what is admissible, Dean?
It means that, so there are rules of evidence that I have to follow. So just for example, one of the cornerstone rules of our evidence is that hearsay is not admissible. So I don't allow a party to discuss or bring a screenshot of a text message that somebody else is saying.
Okay.
So it's admissible by way of rules of evidence.
Now, can I ask this then? Because I'm not the only person that he stole from. There's 5 other people here, and they're all documented. Do I have them come with me to court, or is that a whole separate issue? But they've already been to court. They've talked to the DA, and management has.
Yeah. So theft is a different issue, and theft is not something that I would issue a permanent protection order on. That's not something that the law allows me to protect. That's what law enforcement is there for. And if there's any theft issues, you'll want to report that to law enforcement.
Yes.
That potentially become criminal charges.
Right.
Okay. All right. So we'll see you here on February 11th at 10:30 a.m.
February 11th at 10:30 a.m.
That's right.
And that's a Wednesday. I will see you. And your name again, sir, was?
Magistrate Doak, D-O-A-K.
D-O-K-A?
D-O-A-K.
A-K. All right. Very good.
Right,
thank you for, now, will I get that temporary in the mail, or she said something about an email. They'll email it to me so I have it right away.
Yeah, we'll send it to your email.
Perfect. Okay, so I'll have it right now, or here soon.
So we have that. Yep. Okay, thank you, ma'am.
Thank you, sir. Bye.
Bye now.
Harassing me because I'm African American, and
I have not done
he's
that.
done the worst, and I'm tired and I'm scared, and I can't deal with this anymore, Your Honor. But me and him never.
This is the same judge as her. But instead of just having one person who cannot stop talking, we have 2. And the judge is just completely unable to get a hold of these 2.
Never had any problems. We've never had any problems with. I don't know what happened, but I mean, to me, he's a good guy. But I don't know what happened. But everything I have is destroyed. I just had to close on my back.
Can I say something?
Well, and let's.
If it'll please the court, can I
and you shouldn't talk about any of the facts of the case.
Okay,
those are
well,
things that could-
I'm sorry.
hang on 1 second, sir.
Can I?
So hang on one
Form-
second, Mr.
I might
Brunmeier.
as well talk too, since
I
they are.
understand you want to address what's being spoken about. You shouldn't talk about any of the facts of the
Yes,
case.
you're
Those
right,
can
Your
be
Honor.
used against you.
I will-
Really what I'm
Okay,
trying
sir.
to consider, what I'm trying to consider today is
I'm sorry, John.
the nature of the bond and what to do in terms of the protection order. Mr. Ramsey, can I ask you how far apart are yours and Mr. Brunmeier's apartments?
He lives downstairs, sir. Downstairs, and I mean, I'm not gonna lie.
So how far?
He's
apart,
always
though?
been a great guy.
How far apart are your apartments? I just want to get some.
He's down on the
second
next
floor, Your
level,
Honor.
sir.
So
He's
just
down
just
on the
below.
next level.
Yeah, just below.
Yes, sir.
Okay.
At least 50 feet to 75 feet apart, but just below them, basically, Your Honor.
Okay. All right. Thank you. Miss Alberti, any other record that you'd like to make?
No, I just think I think I said it all. I think the focus really is just getting Mr. Brunmeier back and so he can continue accessing those resources with the VA. And just, he has
You
to,
all gonna. This is not the first time, and I'm never protected. I'm never protected. When am I protected? I go to work, I go to school, I don't mess with nobody, and I never get protection when I ask for help from the residents here. I got a Purple Heart. I got a Purple Heart for fighting for my country, and I got to fight with them because I'm the only black here.
Winston,
that's not right.
Thank you for your service.
Who's going?
Hang on.
Can I
hang on
apologize
1 second,
to you?
Hang on 1 second, Mr. Brunmeier. So I'm not going to allow the parties just to get into an exchange.
Right.
I am here to get bonds set today.
I just want my
So
bond set, Your Honor.
Mr. Ramsey, is it Ramsey or Ramsey?
Sir. Yes, sir.
All right. So Mr. Ramsey, I understand what your position is, so I'm going to take those things into consideration when setting bond and when setting a restraining order. Okay. So I'd like to make my record now.
Your Honor.
So I'd like to make my record now, having considered everything. The court is concerned, obviously, with the potential level of the charges here. At least in the affidavit, there's an indication that there's a class 3 felony, potentially pending charges. However, the court does note Mr. Brunmeier's limited criminal history. There was some juvenile history, but the court noted that in 2024 there was a deferred sentence for a class 5 felony that appears to have successfully been completed. And I don't have any prior failures to appear, which
I never fail.
leads the court to believe that Mr. Brunmeier is willing and able to comply with the court's orders. So I am going to issue a co-PR bond here.
I don't have anyone that can help me sign out, Your Honor.
All right.
I need to be able to do it myself.
All right. So what the court will do then, just given the inability to get a co-signer, I am going to follow the recommendations and set a $14,000 PR bond here. I am going to place, hang on, sir. I am going to place some conditions on bond. I am going to require that you be supervised through pretrial services, through their enhanced supervision. So you'll need to report to pretrial services within 24 hours of your release. I'm going to require that you report to probation as well within 24 hours of your release, and that you remain, hang on, sir, and that you remain law abiding.
Yes, sir.
Because it stems from Title 18 charges.
Oh, Monica, thank you so much. Thank you. All right, here we go. Back to it.
Where it is required to issue the mandatory restraining order, which states you shall not harass, molest, intimidate, retaliate against any victim or witness to this case. And in addition, the court is going to place a no contact protection order naming Mr. Ramsey. Because the parties live in the same apartment, what the court's going to do is provide for a 15-yard distance restriction. And that won't include your apartment. So you can be in your apartment. You just need to make sure that you're remaining 15 yards away from Mr. Ramsey. Okay. So
Yes, sir.
to the extent that there maybe is a different stairwell or elevator that you need to use, you'll have to just comply with that 15-yard distance restriction.
Yes, Your Honor.
Right. All right. So, sir, your next court date is going to be February 11th, 2026 at 8:30 a.m. And that's going to be in courtroom 5C.
Let's see. Sorry, I don't have something to write down with.
And you'll get the paperwork there, your
I'll
bond
get the
paperwork, and that'll have the court date listed on there.
Okay, thank you.
Okay. All right. Thank you. Thank you, Mr. Ramsey.
Yeah, but how far is 15 yards? He didn't explain that very well. All right. Let's do a tiny subset. Tiny subset, mini subset. Same judge.
You have Mr. Nixon?
Yes, Mr. Wayne Nixon.
All right. Thank you, sir. Did you understand your rights on advisement today?
No, I did not, sir.
Did you get provided a handout advising you of your rights?
I did, sir, but I don't understand it because I don't understand. I'm an American citizen, and this is maritime law, and I don't understand why, as an American citizen, under the constitutional law, I have to stand under British maritime law.
Okay.
And
Miss Alberti, did you have the opportunity to speak with Mr. Nixon?
I did, Your Honor.
Would you waive any further advisement?
Yes, I can waive further advisement.
All right. So ultimately, sir, I did find, actually, there was probable cause that was previously found by another judicial officer. There were two charges of related to registration. Both were class 1 misdemeanors, failing to register and then name change. So we are here to get bonds set in your matter today. And I will hear bond arguments first from Mr. Berkey.
Yes, Your Honor. In reviewing the procedural history of the underlying case that he's required to register for, I have very, very serious doubts that this defendant will comply with any bond conditions or be inclined to return for his court dates. So I'd request a cash-only bond. I'd defer to the court in the amount.
Okay. And Ms. Alberti?
Your Honor, Mr. Nixon is also being held in the jail on a $5,000 cash or surety bond. I'm actually representing him. That's an appeal bond. I represent him in that appeal, so I'm fortunate to be pretty familiar with Mr. Nixon. He's been working closely with our office I guess it's a social work intern at our office is her role, but they've been working together, and we've been working on connecting Mr. Nixon with the VA, getting his Social Security payments back on track, helping him get connected to housing resources and just back in track with mental health resources from the VA. He is a military veteran. And Mr. Nixon has made some progress with that in the time that he's been out on bond. My hope, and he's been able to secure housing, and I think he's been able to find to redevelop a community in Larimer County that he kind of lost when he was previously incarcerated. My hope is that Mr. Nixon can keep working on that. He is already going to be struggling to post that $5,000 cash or surety bond. He was held for quite some time looking for a bondsman the first time around. I actually happened to be at the jail when his bondsman they came together to the jail so that she could be removed from the bond. It actually did to me sound like there was a very strange miscommunication between the two of them and why she was deciding to go off the bond. Either way, I don't know. That was just something that I was a witness to. But Mr. Nixon Colorado is his home. He only has one prior failure to appear. He's an appeals client of mine, and he's been very communicative with me. He's made every office meeting we've scheduled. He's been in constant contact with my office.
That just sounds weird for a subset. I mean, the lawyer's doing a great job and he's shutting up, which is weird for a subset. But I think I know why. It's because this isn't a traffic violation. He's a registered offender and he stopped registering. He's in big trouble. And he has another case probably which made him a registered offender. So he's in huge trouble.
I do think that he will follow up and attend his court dates and take care of his obligations for this case.
All right, thank you. So, sir, thank you first for your service. I failed to ask you if you were a veteran or a current member of our military. There should be some resources. There are resources available, and the deputies should have a handout that they can provide you of those resources that you can take advantage of. So taking everything into account, I know it's a relatively high risk category and score of 3 and 14, and the prior failures to comply are concerning to the court in conjunction with the nature of the charges here. So I do think it's appropriate and necessary to issue a monetary bond to ensure Mr. Nixon's compliance and for community safety reasons as well. The court will set a $250 cash bond. And so conditions of that bond are going to be that you remain law abiding. I am also going to order that as a condition of bond, you comply with the order to register that stems from 24M 954. So your next court date, I also need to issue the standard Title 18 restraining order, which states you shall not harass, molest, intimidate, retaliate against, or otherwise tamper with any victim or witness to this case. Your next court date is going to be February 5th, 2026 at 1:30 p.m. That's going to be in courtroom L2. All right. Thank you, sir.
So we just saw 3 cases from 1A in Denver. We never get to see 1A. They do not stream very often at all. So 1A is like the sister court to 1H, which is Blanco. So it's another mental health docket. So normally the person in 1A is Judge Arnold's, and she doesn't stream. So it's rare that we get to see 1A. And it's rare you guys get to see 1A at all because it's only here on this channel. No one else has these. Let's go to no. All right, here. This is fine. Judge Hall. I love Judge Kim Hall.
Very good.
Indiana.
Then let's, who you want to talk about next? Mr. Gold?
Judge, let's talk about Corbin Marshall.
Okay. Corbin Marshall, your bond is $7,500 cash. And I think I have a report from, I do, Mr. Phillips. And then while I'm looking at this, Mr. Gold, you want to talk about Corbin?
Yes. Judge, recommendation regarding Corbin is that he remain in custody because he doesn't qualify for the presumptive release. This gentleman has a pending meth case from September of 25 in Porter County, which he bonded out on. He has a public defender there. He has another possession of meth case in November of 25, which is an F5. He has he bonded out there, and he has attorney Shagerloff. And then this pending case is an overdose, which they tried numerous times to bring him back with Narcan, and finally he came back. So the And he mentions in the report, Mr. Phelps mentions that this young man does realize it's time to address his substance abuse disorder. And, you know, I don't know what he can post or not, but, you know, as far as the MRT or some kind of programming now, I think would be the best thing for him, at least to begin.
Thank you. Prosecutor?
Your Honor, I would just ask for the bond remain the same at this point in time. I don't believe he may potentially be a flight risk, but being out on bond on 2 other possession cases, and then now the new alleged offense being an overdose, unfortunately for Corbin, and he's going to disagree with me, I think the safest place for him right now is under the conditions of bond in the Stark County Justice Center. And I would ask that if the court were to do that, that he would at least try to start getting into the MRT program. I'm just worried we release him again a 3rd time, you know, he's not going to make it back. So that's the state's position at this point in time, Your Honor. Thank you.
Thank you. Did you wish to say anything, Corbin?
Yes. If I like disability, that's my income. If I spend more than 30 days consecutive in rated, I'll lose my income. I won't be able to get it back. I'm not a flight risk. I come to all my court dates. I've hired attorneys for both my other cases, and I'm hiring this case as well. I don't believe that I believe it's fair for me to possibly get a bond reduction. I'm not a flight risk. I don't want to lose my income.
Yeah. Are you aware of what happened?
Yes.
And you think it's a good idea that you walk out of the Justice Center and go back to your life as it was when apparently you were very close to not being here today?
No, I mean, maybe not just. I'd be willing to do drug screening or whatever I have to do to be able to pre-trial is an option.
I understand. But we don't need to do drug screens if you're in jail, right?
I understand that.
I've let people out and they overdose in 3 days and died.
I promise you I won't be that case.
Okay. Well, if you are, it won't do much good that I say, Corbin, you promised.
No, I understand.
I'm going to say this one time for everybody, because it applies to so many of you. You're charged with a drug offense. And many people charged, independent of the legal problem.
Thank you.
They have a physical and mental problem that could take their life. And this court will give you significant consideration for anything you do after today to try to get over this addiction you have with whatever or multiple substances that you consume. Some people do get incarcerated for long periods of time. Some people go to prison. Not a whole lot. Most, we focus on treatment. But in the jail, they have the moral recognition therapy, MRT program, that many people come to court and say that it helped them so much. So I'm in charge of the legal part of it, but we've been doing this with so many people with drug addictions for so long that I just want to make it clear to all of you, any attempts, whether it's Port or Stark, to be evaluated and participate in their treatment programs, whether it's a different facility like Bowen or Fort County, if it's go to a residential treatment facility, if people are incarcerated with a bond and you want to go to a residential treatment facility and they have a bed for you, I'm very open-minded to modifying bonds to let people on the condition you go to your treatment facility. And so, I'm not changing the bond, Corbin. I'm not letting you out under these facts that, or the affidavit of probable cause today. You can talk to your lawyer in the future, and Mr. Phillips. And I would suggest the way for you to get out is through a bed at a residential treatment facility. And these are the people who would make that happen. But when it comes to just modifying the bond with a person with, I think, two other pending cases, is that right?
Correct.
Yeah, 2 pending cases. At least one is here, right? One, or do you have more than?
One of them is insurance.
Okay, so yeah, this is the problem because you can't break the law while on probation or strike that while out on bond and expect that we don't pay attention to that. We do, and it could be a violation of your bond, and you could be put back in jail on the other case. So I'm gonna leave it there. You can talk to Mr. Shargaloff and maybe he can come up with something, but it's unlikely that it's going to be reduced so that we get the possibility of a repeat of police giving you Narcan, see if your heart will start again. Okay, court system, in my judgment, is not, I can't keep your heart pumping. I can't. But I can keep you in jail, and that keeps your heart pumping usually. But anyway, anything else to talk about there, Mr. Poulos?
No, Your Honor.
Thank you, Judge. Thank you. Probably saved that guy's life. Let's go to Judge Fish. We haven't seen Judge Fish in a while because he hasn't streamed in a while. But then he streamed 2 days in a row. So let's go to Judge Fish. Can we see Judge Fish here?
No, Your Honor. Thank you.
We're adjourned.
Thank you, Judge.
Good day, sir. Let's do Kalen Kraft. Good morning, Judge. I might have put 2025 on every single other thing I've signed today. It's possible. Good morning, counsel. You want to set our record?
Yes, this is State of Indiana versus Kalen Kraft, cause number 64D01, 2405 F6 4620. State of Indiana, presented by Deputy Prosecutors Pavlovsky and Poulos. Defendant appears in person, pro se. We are set for a change of plea hearing.
I did sign your motion yesterday to set today's hearing.
Thank you, Judge. And I do apologize. I see in your last order from earlier this week that you did give us a deadline of Wednesday PM. There was just some complications getting that plea finalized and signed. We did get it filed Thursday morning, so I hope that's acceptable with the court.
Well, given the option of going to trial next week or accepting this plea, seems pretty clear to me that in the interest of expedience and judicial economy, it's smarter for me to allow you to do the change of plea.
I appreciate that. Thank you.
Yeah, as soon as the file comes up, I can get into it. Morning, Mr. Kraft.
Morning, Judge.
I'm going to pull the mic closer to you. That way you don't have to try to lean in so much.
Can you hear me now?
If you grab the mic, you can just pull it closer.
Okay.
You can pull it all the way to your face if you want. Please raise your right hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. And please state your full name for the record.
Kalen Shamar Kraft.
Have you ever used any other names?
No.
How old are you, sir?
27.
The court has been informed that you wish to change your plea to guilty on count 1.
So I did leave in him reading all the rights and everything, but I'm not going to a lot in the future because once we get an idea of what he says here, we don't have to hear it a million times. However, some people have never seen Judge Fish before. So while everybody's getting used to Judge Fish, I did leave it in. Just like I don't leave it in for the people in Georgia anymore. I never leave it in. I will for a little bit longer for Judge Fish because he's very strict and military. I mean, military is the best word to describe this judge. And you can hear that in every sentence.
That it'll be entered as a Class A misdemeanor. Is that correct?
Correct.
And before I can accept any guilty plea, I need to ask you some questions. At any time you don't understand a question, let me know and I'll explain. Anytime you'd like to speak with your attorney before answering, let me know and you'll be allowed to do that. Have you ever been treated for any mental illness, or do you now suffer from any mental or emotional disability?
No.
Are you currently under the influence of any alcohol or drugs that would impact your understanding of today's proceedings?
No.
To count one, theft, a level 6 felony, to be entered as a class A misdemeanor, how do you now plead?
Guilty.
Mr. Kraft, you have the right to a public and speedy trial by jury. Do you understand that?
Yes.
You have the right to face all witnesses against you, to see, hear, question, and cross-examine those witnesses. Do you understand that?
Yes.
You have the right to require witnesses to be present at any hearing or trial to testify on your behalf, and the court will assist you in exercising that right by issuing subpoenas. Do you understand that?
Yes.
The state of Indiana must prove beyond a reasonable doubt that you committed the offense charged before you could be found guilty of that offense. You understand that?
Yes.
You could not be forced to make any statement or to testify against yourself at any hearing or trial, but have the right to remain silent. Do you understand that?
Yes.
If you were to have a trial and were found guilty, you would have the right to appeal your conviction to the Indiana Court of Appeals. You understand that?
Yes.
By pleading guilty, you're giving up all of the rights that I've just gone through. You understand that?
Yes.
You have the right to be represented by an attorney at all times, including trial and appeal. If you cannot afford to pay for an attorney now or at any future time, the court would appoint one for you. You understand that?
Yes.
By pleading guilty, you're admitting that everything the state would have to prove beyond a reasonable doubt for you to be found guilty is in fact true. You understand that?
Yes.
And by your pleading guilty, the court will proceed with judgment of conviction and sentencing without a trial being held. Do you understand that?
Yes.
Last time we were here, we exhaustively went through how you're representing yourself pro se in this matter. Is that correct?
Yes.
And you understand you're held to the same standard as an attorney in that regard?
Yes.
Okay, thank you. Possible penalty for a level 6 felony is from between 6 months to 2.5 years in prison and up to a $10,000 fine. Do you understand that possible penalty?
Yes.
Possible penalty for a class A misdemeanor is up to a year in jail and up to a $5,000 fine. Do you understand that possible penalty?
Yes.
If you have any previous criminal convictions or previous juvenile delinquent adjudications, those may cause an increase in your sentence, or they may prevent the court from suspending part of your sentence. Do you understand that?
Yes.
Are you currently on parole or probation anywhere?
No.
Other than this case, are you out on bond on any charges anywhere?
No.
This plea of guilty may cause harsher sentences for any future crimes. Do you understand that?
Yes.
Court was presented with a 4-page document entitled Recommendation of Plea Negotiation. The document appears to bear your signature right at the top of the 4th page. Looks like an electronic signature, sir. Did you sign this document?
Yes.
Did you use a computer to sign it?
Yes.
Before you signed it, did you read everything in it completely?
Yes.
Before you signed it, did you consult with anybody else about its terms, like an attorney or anybody?
No.
Okay, but before you signed it, you believe you understood everything in the document completely?
Yeah, I went over it with the prosecutor.
You understood its terms completely, sir?
Correct.
Okay, thank you. As I understand the sentencing portion of the agreement, you'll be sentenced to 180 days in the Porter County Jail. All that time would be suspended. You'll get credit for the time you served on April 30th of 2024. The balance of 178 days will be served on administrative probation, non-reporting. You'll have a full probationary term to pay restitution in this case. The matter would be automatically expunged upon your successful completion of probation, and you can petition the court for early termination of probation if you pay the restitution early. There's an amount of restitution of $3,209.88 to the victim that would be paid as a condition of probation. Is that your understanding of the terms, sir?
Yes.
Okay. And I told you you'd get credit for your time served awaiting disposition. You understand that?
Yes.
You realize I'm not a party to this agreement, but I'll be bound by its terms at your sentencing and with respect to any future sentence modification if you ask for one?
Yes.
Have you or anyone else received any promises or been given anything of value to cause you to enter this plea of guilty?
No.
Has anyone forced or threatened or placed you or anyone else in fear to cause you to enter this plea of guilty?
No.
Okay. Sir, you were in Porter County on April the 30th, 2024. Is that correct?
Yes.
And at that time, did you exert unauthorized control over property belonging to AT&T?
Yes.
Looks like it's alleged that you took electronic funds, currency belonging to Prime Communications, and then created some fictitious transactions with Apple AirPods and refunded those transactions to get gift cards and credit cards linked to your account. Is that what you did, sir?
Yes.
You performed 6 transactions, resulting in a total loss of the $3,209.88 to Prime Communications?
Yes.
And it was your intent that day to deprive Prime Communications or AT&T of that currency. Is that correct?
Yes.
And the total loss then you would agree is over $750, but less than $50,000.
Yes.
State?
One more question, Mr. Kraft. Would you agree that Prime Communications and AT&T, for the purposes of this case, are the same entity?
Can you repeat that one more time?
AT&T and Prime Communications are basically the same company. They're just
Correct. Third party.
names of the same company.
Correct.
No further questions. I'll stipulate to the probable cause affidavit as a.
Yeah, we'll enter the probable cause affidavit as as additional support rather for the factual basis or providence. I don't have any other questions, sir. The court finds the defendant understands the nature of the charge against him to which he's pled guilty. That he understands the possible sentence for that charge, that his plea has been made freely and voluntarily, and there's a basis in fact for the plea of guilty. We're moving into sentencing, State?
Yes, Your Honor. I also have a state's motion requesting restitution, if I may approach.
Yeah, if you want to come up here with that, that'd be fine. Thank you, sir. Do you have any evidence or argument for sentencing, sir?
Your Honor, the defendant has one prior criminal charge that I've seen. It was a portage case that was resolved through a plea agreement to a misdemeanor. He has no felony history. I understand the terms of this plea are a little lenient, let's say. However, the state's primary concern was to obtain the restitution for the victim in this case. This plea accomplishes that. So at this point, the state would just request that the court accept the plea as tendered.
Thank you. Mr. Kraft, you're acting as your own attorney, all right? So it's a little tricky, but you've got the opportunity to present any evidence you'd like to present related to the sentencing or any argument you'd like to make. But after that, you also have an opportunity to do what's called an allocution when you talk to me about the charges. Combining that can be kind of confusing, so let me just ask you first, do you have any evidence or argument related to sentencing?
No.
Okay, sir. And then is there anything you'd like to say before I enter the sentence, before I make my decision related to the sentence?
No.
Okay, that's fine. Well, at this time, the court will accept the recommendation of plea negotiation. Pursuant to that, enter judgment of conviction on count 1, theft, a Class A misdemeanor. Sentence you to 180 days in the Porter County Jail. Credit for the time served from April 30th, 2024. You'll spend the balance on administrative probation. You'll have the full probationary term to pay restitution. There'll be an automatic expungement at the completion of probation, so long as you complete it successfully. And you can also petition for early termination of probation if you've paid the amount of restitution in full. We are going to take $1,500 of your bond towards the $3,209.88 restitution. But that leaves you with the remaining restitution. You also have to pay your fines, fees, and court costs because there's only $1,500 of bond here. So you'll have to pay the court cost, probation initial administrative fee, jail booking, and sheriff's death benefit fee, and that's going to be another $300 or so. Okay, just so you're aware. You understand all that?
Yes.
Okay. From the cash bond, the court will pay $1,500 towards the restitution. I need you to go from here to the probation department and get started on the terms of your probation. You know where their office is located, sir?
No, I do not.
It's at 157 Franklin Street. So you're going to walk out the courthouse and veer left down the sidewalk, halfway down the block on the left-hand side, just past the elections office. You can go up on the second floor to the probation office.
Okay.
And get signed up with the administrative probation. Okay?
All right.
When you're paying your fines, fees, and costs, you can pay those down at the clerk's office. You can pay the remaining amount of restitution there as well. Okay?
Okay.
Do you have any questions about anything?
For that conviction for a misdemeanor, it was under theft or conversion?
It's theft conviction as a Class A misdemeanor.
Okay. Is that a question for the state?
Was it supposed to be conversion? Your Honor, during the discussion, it was discussed possibly amending it to a conversion charge. That's not what we ended up doing. I know it's a little late in the game now. If the defendant wants it entered as a conversion charge, I have no objection to that, but I don't know procedural if we're beyond that point. I know at the end of the day, the conviction is getting expunged, so I think it might be a little bit of a moot point, but I have no objection if he wants it entered as a conversion, if that was his understanding. I don't want to give the impression that the state offered something and then. Yeah, I understand. We hate to say it, but it's a distinction without a difference in this case. It's got a very significant difference at common law, where conversion means that you took the property, but you meant to give it back, right? Or you're only going to use it for a short period of time. It gets rid of that element of depriving the owner of the property permanently, right? That's the element that would change. I don't have any problem with if you want us to use the word conversion rather than theft. It's a lesser included, so that changes the vibe a little bit. And rather than me entering a Class A misdemeanor of theft, what I'd be doing is entering a lesser included conversion as a Class A misdemeanor. Okay, so we're clear. The factual basis supported a theft, but we'll do it if that makes you feel better about it.
Yes, I would like that.
Okay.
I have no objection.
And if the state doesn't object, we can do it that way. We'll do a little bit of wordsmithing on the document to make sure our order's clear. Nothing changes the record that we've recorded from the proceedings here this morning. But in any case, Mr. Kraft, it doesn't change the bottom line for you, which is that you still owe some restitution, some fines, fees, and court costs, and you'll be expected over at the probation office here within the next few minutes to get started on probation, okay?
Yeah, that's fine.
Do you have any questions about anything?
No, Your Honor.
The other thing I'll do is vacate the trial setting that was supposed to proceed on Tuesday. So we'll vacate that. Nobody's expected to appear, obviously, because your case has been resolved and it is procedurally moot. Do you have anything else you want to cover with the court today?
No, Your Honor.
Okay. Anything else from the state of Indiana?
No, Your Honor. Thank you.
All right. We're adjourned. Thanks for working it out, folks.
Thank you.
Thank you.
All right. Good luck to you.
Thank you.
Friday ball away at 11 with our 10 o'clock. Two cases we had at 10, right? Ms. Rimley said she was going to appear by Zoom, but I don't see her.
Miss Rimley said she's going to appear by Zoom, but I don't see her.
Did she continue that? Are you Mr. Ilgenfitz? Or, well, State, would you please set our record?
Yes, Your Honor. Thank you. This is State of Indiana versus Joshua Ilgenfritz. The cause number is 64D01-2407F67920. The defendant appears in court in person without counsel. State of Indiana by Gary Gurman.
I'm just trying to pull your file up, sir. All right, back on December the 5th, you were in court. You told me you planned to hire a lawyer. No lawyer appeared. Then again on December the 19th, you told me you're going to hire a lawyer. No lawyer has appeared. You were aware that today's a final revocation hearing on the probation matter. Are you prepared to proceed, sir?
I actually have a legal counsel, but he, within the last 2 or 3 days, I was notified that he was actually in court somewhere else, I believe in Lake County. So he wasn't able to make today. Legal counsel is Roy Dominguez.
Okay, nobody entered their appearance in the case, sir.
Oh, well, I talked to him last night, and I have the the check for him. I'm supposed to actually leave here and go see him at his office at 2:30. But he told me on the phone that he was my my legal representation. He just couldn't make it this morning.
I'll set you over until
Maybe because you didn't pay him to make it this morning.
next Friday
Hi, Birdie.
at 10 a.m. You're ordered to appear back here Friday, February the 6th at 10 o'clock. And if counsel doesn't have their appearance in at that time,
Okay.
we're going to proceed with the final revocation hearing. Do you understand?
Absolutely.
Okay. We're adjourned.
Okay. February the 6th, you said, right?
I'll give you a note here.
Okay.
Thank you, Rory. I saw something from Miss Brimley. I thought it was a request to appear by Zoom, though. Might not have been on this case. Let me open the file up, Mr. Prosecutor.
Yeah, thank you, Your Honor.
I don't see Miss
Monica,
Staton
thanks for
either.
the cheers. Thank you.
Oh, she called this morning?
I can't hear what this lady's saying, but she called. She called and she knew she had court today. This lawyer. Nan, did you find your glasses?
So Ms. Rimley appeared back on December the 4th. I'm willing to take my recess and look at how we're set at the 11 o'clock. We have her or Ms. Rimley at that time. This is not the case where Ms. Rimley offered to appear by Zoom, but I definitely see her appearance entered and that Mr. Pribble had withdrawn based upon the entry of appearance of Ms. Staton. Not Ms. Staton at all, Ms. Rimley. Okay, well, we'll see how that goes. I'm in.
There you go. Oh, está bien. No sé, no.
State, would you please set our record for Jessica Staton?
Yes, Your Honor, thank you. This is State of Indiana versus Jessica Staton. The cause number is 64D01-2209F67597. Staton is present in court in person. Her name is Robin Remley, is present in court by video conferencing. State of Indiana by Gary Gurman.
Thank you. Morning, Ms. Staton.
Hi.
Ms. Rimley, can you hear me okay?
Yes, Your Honor, and I do apologize for my Zoom appearance. Apparently, I didn't check a box that gives me alerts, and it wasn't on my court calendar. However, I was in open court when this date was assigned, so I do apologize.
Yeah, I don't see you I don't see your appearance entered properly, right? So something's going on at the clerk's office.
Exactly, but I was there, so it's still my fault, Your Honor, so I
My
do
staff
apologize.
suggested that you said maybe you could they could let me know you weren't going to be here. That's wholly unacceptable.
I understand
And
that.
you definitely would want to be here. Or I will set show cause hearings where you can come show cause why you would fail to appear.
Oof. No, he's not going to. He's threatening to, but he means it. He definitely means it.
So, but that's not where we're at today. Today we need to handle this matter post conviction, and we had an admit deny hearing back on December the 22nd. I set it for final revocation for today. Mr. Prosecutor, how would you like to proceed with the final revocation hearing?
Yeah, thank you, Judge. Judge, I'm going to, if with your permission, give the defendant maybe 30 to 45 days so that we can attempt to resolve the matter. I will ask that she report to probation today for a drug test. And so 30, 45 days, if that's okay with counsel.
Okay, Ms. Rimley, the state has suggested maybe I continue today a little while longer, give you some opportunity to try to work it out. Is that what you have in mind as well?
Yes, Your Honor, I have some other matters to discuss with Mr. Gurman, so I can try to handle all of those things, hopefully. And that would be great.
I'll set it over until March the 13th at 10 a.m. Are you available that day, Ms. Rimley?
Let me check your now. Yes, Your Honor.
All right. We'll have you back March the 13th, 10 a.m. You're ordered to appear.
Yes,
And
sir.
if you would go to the probation department and check with them and do a drug screen, that'd be fantastic.
All right, thank you.
Okay,
Thank
thank you. We'll
you.
see you back March the 13th. We're adjourned.
Thank you.
Thanks for coming out. I know you had some car troubles. Everything sorted out for you? Okay, we're adjourned.
I think she thought he was talking to her for a second, but he wasn't. If that lawyer does not show up again, I remember Judge Giles. He really, really ripped into Trinity, I think his name was, or Tristan his name was. I can't remember his name now, but he annihilated this judge for always being late. And I wanted to follow up to see if this lawyer was late anymore, and Judge Giles stopped streaming, which sucked because I loved his courtroom. Let's go to Wisconsin. Light Wisconsin accent. Enough to say, oh, that's Wisconsin, but it's not really. Everything's light today. A light subset, a light Wisconsin, but there's a tweaker.
Explain that. 23 CF 858, where he failed to appear on June 10th of 2024 and a warrant was issued. He also failed to appear on September 25th of 2024, where a warrant was issued. I say that the case is pending, but he pled guilty on this case, or no contest, just this week on January 26th. It was set over for sentencing. The judge admonished him on the record that he was going to remain out on bail, even though a conviction for a felony of delivery of methamphetamine had been entered on his record, and the judge advised him to not break any laws or not get into trouble while he was out on bail. That was on the 26th. Here we have this probable cause statement. Just 3 days later, with him in possession of methamphetamine while he's awaiting sentencing for the delivery of methamphetamine.
I would hate to go through withdrawal, all right, like he is. He's clearly suffering right now. But imagine going through withdrawal and then having to sit through a court hearing. Just sit there. You're not allowed to talk.
The other case, 24 CF 668, was also a possession of methamphetamine. The state is requesting a $5,000 cash bail. We are also requesting a condition of absolute sobriety.
Attorney Heim, do you wish to respond?
Just briefly here, we'll ask for either the court to consider a lesser cash bond or a signature bond here, noting he does not have any cash available to post for a cash bond. He has significant ties to the community. He's provided an address here in Manitowoc County. He's lived in the county his whole life, has family living in the area. The allegations here are that it was a relatively small amount of meth, and he was cooperative once stopped. So for those reasons, we're asking for you to consider a lesser cash bond or a signature bond. Thank you.
Thank you. What's mainly concerning is not the amount of methamphetamine, the fact that it was found very recently after admonishment from the judge for conviction of a delivery. Having a very difficult time following the conditions of bail. And there's the concern that this would happen again or something similar, or his behavior would cause him to not make himself available for court is appropriate to set cash bail in this case. While not a lot of meth, while just being convicted of delivery of meth and awaiting sentencing for that, to then have meth on your person.
All he wants right now is a hit of meth. And all they keep saying over and over and over again is meth.
It's pretty aggravated. And it's very dangerous. So I will set the cash bail in the amount of the $5,000 with the absolute sobriety condition. Initial appearance is February 2nd at 1:30 p.m. in Branch 1 of the Manitowoc County Courthouse. Failure to appear at that, a warrant would issue. Failure to comply with any conditions of bail would result in new charges. I do believe Mr. Yelvington has stepped out.
He's gone. He left. He said, I'm done with this.
I believe that is all of the bail for the week. We are adjourned.
Poor guy. I feel bad for him. Maybe, who knows, maybe he'll get treatment in jail. Let's see. That's too long. I'm looking for something. Let's go to Georgia again. Whoops, let's go to this guy.
Probably next week. But there's nothing that I can do to, I cannot. It is not possible at all. It's not because I don't want to, it's just because I actually literally cannot do it. Okay? Because Judge Bearden's not even here today, right? I don't think so. Yeah, I don't think he is. So unfortunately, you have to sit with me for the weekend. But like I said, hopefully we should be able to get something figured out. Hopefully Monday, if everybody's working hard for it. We'll have to see with the weather and everything, okay? All right. I know that's not what you wanted to hear. All right.
No bond for you, sir.
Mr. Abeda? Okay. All right, I have you here on several charges. They're all misdemeanor charges. I've got 3 counts of cruelty to children in the 3rd degree, 1 count battery family violence, and 1 count simple assault family violence. Do you understand all of those charges?
Not fully.
Okay, let's go over them a little bit. Is there any that you do understand or not understand?
I guess it's more of the children one.
The children one? Okay. So the battery was for grabbing Lisa's arm and attempting to retrieve car keys. The simple assault was for throwing a knife. And then I've got the 3 cruelty to children. Cruelty to children is when you, having been determined the primary aggressor and having knowledge that a child under the age of 18 is present and can see or hear the act of you committing a battery family violence against the alleged victim, and you did allow that child to hear or see. Specifically, you have 1 for Maya, 1 for Raymond, and 1 for Zaylee. Okay, does that make sense now? Okay. All right, so you understand all of those charges, what you're fighting, right? Okay. All right, state is the bond.
Judge, I don't have
any recommendation in regards to a bond amount. But the state, obviously, given the nature of the warrants and the fact that there was a knife, is concerned about the safety of the family members. So the state's going to be asking for no contact with the wife and the children, not to return to the residence, and to have no firearms or weapons, and any other special conditions Your Honor thinks is appropriate.
And I forgot to ask this, you're looking for a public defender, correct? All right. All right, bail is going to be set at a total amount of $13,000. Going through a bondsman with a 15% post, that's $1,950 to post and be released from custody, okay? As far as conditions, fairly simple. Don't violate local, state, or federal laws while the charges are pending. You're not to be in possession of or control of any weapons of any kind while the charges are pending. No contact with, use, possess, consume any alcohol, narcotics, or any other drugs unless lawfully prescribed by a medical provider. If you have controlled substances that you take, just make sure that the public defenders know that you have those and everything, just so that we can all be abundantly aware of what's going on. Additionally, like if you get into a car accident or something and they prescribe you a pain medication for a broken arm or something else like that, I obviously want you to take whatever's prescribed by a medical provider. I'm not here to play medicine or practice medicine, but just let us know that you have that and that it was for this particular reason, okay? And then I will accept the state's request for a no contact order for direct or indirect contact with any victim, witness, and not to come within 500 yards of the residence, place of employment, school, place of worship, any victim in the case. Any questions?
Is that until all proceedings have ended?
Until all proceedings have ended or modified. Okay. Any questions? All right. And then you're Mr. Harvey, correct? All right, Mr. Harvey. I've got you as a May 28th, 1991 and 3/1 perfect. And then you were wanting a public defender as well, correct?
Yes, sir.
Perfect. All right, 2 charges for you. I have both misdemeanors, simple assault, family violence, and criminal trespass, damage to property. Do you understand both of those charges?
I don't know how criminal trespassing.
Okay.
I live there.
Okay, let's go over that one. So you understand the simple assault, you understand what you're fighting on that one. Okay, good. All right, so let's see. This one says that you damaged the property of a Laura Capizzi without her consent, and the damage was $500 or less. It did knowingly and maliciously interfere with the possession or use of the property of another person. Looks like you specifically broke a lamp that was
What's the trespassing? What's that?
when it's less than $500 and it's damage to property, it's just called criminal trespass. It's just the way that they wrote it.
My own house, right? Correct?
It doesn't matter. It doesn't matter about it being in your house or whatever. It's not about going into the property. It's about you having broken the actual lamp. That's all we're talking about. Is just the lamp.
So I just can't be damaged. Why not?
Because it's not above the setback. If you have to listen to your criminal trespass, it will go down and take it down.
Yeah.
So there's 2 different things.
Yeah. There's a second little subsection in there for it.
Yeah, because I was just told that I just had a simple assault and then all these other things came.
Yeah. So it's just this is just specifically for breaking the lamp. So it's the simple assault for placing her in fear of being hurt And specifically, it was while you punched the lamp.
I'm really the victim.
Okay. I get you. I hear you. I hear you. All right. But you understand what you're fighting, right? Okay. State is the bond.
Judge, nothing in regards to the bond amount, but just given the charges, no contact with the victim and not to return to the residence.
Okay.
Then again, I've been there for 4 or 5 years. I don't get that. I really don't get that at all.
Okay.
So y'all gonna throw me out of my own house because of some woman don't want to do right, basically. And now I gotta leave because but it's fine, but I just can't go there and just up and leave. I need time.
I understand that.
You know?
So what I think is in Dawson, I don't think they have separate courts for anything. We've seen this guy do tax, probate. Yesterday we saw landlord tenant yesterday, I think. I can't remember. No. Yes, we see him do a lot of landlord tenant, but yesterday we saw an employer who had to pay a paycheck to a guy from years ago, and then today it's criminal charges. So I think it's a little bit of everything.
So tell me a little bit about the property. Is it owned by you? Is it a rental?
It's a rental.
Okay. Are you the primary lease?
No, but
Okay.
That's not the thing.
No, I understand that.
The thing is that's all I got.
I got you.
Literally.
I got you.
And all right, whatever.
No. Listen, I'm just trying to get.
It's for the better. It's fine. It's fine. Yes, sir.
I get you. All right, so here's what we'll do. So I'm going to do $4,000 on the bond, okay? Through a bondsman at 15%, that comes out to $600.
I can't even afford that.
You can't afford that.
I can't. Unless she help me out, because she's my only help in her only help. I don't get it.
Yeah, I mean, with the simple assault, that's going to be about the lowest that I can go just on that, okay? So we'll leave that there at $4,600 to get out. The conditions that I would put in place if you do get out are the not to violate local, state, or federal laws, no possession, use, or consumption of alcohol, narcotics, or any other drugs for me, and then no contact with the victim, not to go within 500 feet, okay? What I will do is, again, I understand that you may not be able to get out. I get that. I'm going to add a separate condition on here. It's a one-time return so that you can get any sort of personal belongings or anything like that. The only thing that I ask is that it's coordinated with Dawson County Sheriff's Office.
I have to figure out things first before I can even take a step. That's what I'm saying.
I understand. That's all that I can offer right now is that if you are able to bond out, you can at least return back to the property one time to get.
I ain't gonna be able to get all my things at one time.
I understand. But you can at least get as much as you possibly can.
It's still not making no sense that I've been there just at the same time, and now I get put in jail, and I gotta be the one who just up and leave without even having anything, nothing. But I don't mind leaving the place at all because apparently she's a sinner, okay? So therefore it's fine. So I just need.
She's a sinner.
I just can't have one day or one time to get all my things. I'm definitely gonna get in trouble again trying to get the rest of my things because it's not just that easy to just up and leave when I've been there for 5 years.
Okay.
Y'all make it so easy for me to just step out and just leave when, I'm just gonna need more time than just one time to get my things. That's all I'm saying.
I understand.
I remember that it used to be like a month thing, like, have enough time, not like to be rushed to be like, I gotta go. Like, no, that's not how it's supposed to work.
So, so here's the thing. I'm going to talk to you practically about it. If this were an eviction case,
Yes.
the only thing I'd be able to give you is 7 days. That's it. By law, on an eviction, the only thing I can give you is 7 days. The reason why it's 1 day for this, because I have to limit as much of an interaction between you and her as possible. Does that make sense?
She's never home.
I understand that, but I have to protect what I can protect. I have to protect and do everything I need to do. So it's the one time.
When I'm really the victim.
Well,
That's all I'm saying. I'm really the victim.
look at it from this particular situation.
Yes, sir.
This stops you from getting accused of something else.
My life would be so much better without her, so.
I hear you. I hear you. All right. Any other questions?
No, sir.
All right. Perfect. And that is all I have for you. Thank you so very much. They are good.
Yes, sir.
Thank you.
We're gonna go back to what we.
All right, that was our no camera stream. Sorry guys, my eye is really, really bothering me, so no. I don't have any lights on, so I didn't put my camera on. I'm going to set up OJ now. I'm thinking about doing a long OJ day today because we're in the middle of the closing statements, and it's really freaking annoying when I hit the 2-hour mark and I have to stop it. Zach, thank you so much. So, if not, today's Saturday, so I won't see you all until tomorrow night. I hope that you guys have a great day. Thank you so much for coming out. And I'll see you all again real soon, all right? Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,